Hello everyone, welcome to the daily editorial analysis brought to you by Shankar IAS Academy, 20th March 2025. Displayed here are the list of articles that we'll be discussing today. The first article, anti-torture law. We know that the India so far haven't ratified the United Nations Convention against the torture, and we don't have a standalone law to deal with the torture in the custodies. And this article is talking about the concerns associated with this and how it is damaging the India's global reputation as a human rights advocate, and how it is affecting the India's judicial system and justice. And this article is taken from the newspaper The Hindu. And the second article, Telecom Tribunal reforms to handle data protection, please. The article is taken from the newspaper The Hindu, which is talking about the recently released draft of the digital personal data protection rules 2025. And in this topic, we will be discussing what are the concerns associated with this rules of 2025 and what are the reforms can be taken. So without much delay, let's get into our discussion. Torture shadows India's justice system. The article is taken from the newspaper The Hindu, which is talking about India's failure to criminalize torture, and it weakens the Indian judicial system and global reputation, because in the year 1984, almost every developed nations in the world ratified the United Nations Convention against torture. But India signed this in the year 1997 but did not ratify the convention so far. And recently in the United Kingdom, as well as the Supreme Courts of United Kingdom and the United States, has raised concerns about the custodial torture in India. And we know that recently the Trump administration accepted to transfer Tahavur Rana, one of the conspirators in the Mumbai terror attack of 2008. And in that case also, the United States Supreme Court raised concerns about the person in India. So coming to the legal framework for torture. See, before that, we have to understand what is meant by torture. Torture, according to the United Nations Convention against the torture, torture means an act of intentionally inflicting pain or suffering on another person, both psychologically or physically. And in the case of India, we don't have a specific law to deal with the torture, but we have constitutional provisions, that is Article 21 of the Indian Constitution, that is right to life and personal liberty, which ensures freedom from torture. And then we have the Article 20 Clause 3, which Article 20 provides protection against arbitrary arrest, and that protects the people from self-incrimination. That means the police or authorities cannot force a person to confess that he committed the crime, and they cannot ask the person to submit evidence against himself. And also we have certain Supreme Court cases, so you can address these cases while you are writing an answer. First is the DK Basu case 1997, and here the Supreme Court provided guidelines against the custodial torture. And then we have the Puttaswamy versus Union of India case 2017, and here the Supreme Court reinforced the guidelines and also reinforced the principles of dignity and the right to privacy. And then next we have the Ashwini Kumar case 2019, which recognized the need for an anti-torture law in India. And coming to certain recommendations, the Rajya Sabha Committee 2010 and the Law Commission of 2017 urged a standalone anti-torture law in India. So coming to the international commitments, we have the United Nations Convention against the torture, and this was adopted in the year by the United Nations General Assembly in the year 1984, and India signed this in the year 1997 but did not ratify so far. So what is the meaning of signing and ratification? Signing means we are ready to consider that we are accepting the existence of such an convention or a treaty, but that will be legally binding only if we ratify the convention or the treaty. And this approach of India, placing India among the nations with the poor human rights records like the Burkina Faso, Sudan and all. And coming to the constitution mandates, Article 51 Clause C and 253 empowers India to enact laws aligning with the treaties, but no actions have been taken so far. And coming to the challenges in enacting an anti-torture law in India, first is a political and bureaucratic apathy. That means we can see the Rajya Sabha Committee made the recommendation for a standalone law against the torture, while you can also see the Law Commission also made the recommendation, but still it is ignored by the government, by the different governments. And the next is police brutality and lack of accountability. That is, torture persists due to weak enforcement of the law. And the next is a weak oversight mechanism. There is no independent authority to monitor the custodial violence. There we have the State Human Rights Commission, National Human Rights Commission, but still you can see that they perform multiple functions. but there is no independent authority to monitor the custodial violence alone. And the next is fear of international scrutiny, that is ratifying the United Nations Convention Against the Torture would invite global human rights monitoring in India. And coming to the implications of this inaction, that means India has not ratified the United Nations Convention Against the torture. So what are the problems may arise from this? First one is the hurdles in the extradition. That means, like I mentioned, in the cases the Tahawur Rana, the United States Supreme Court has raised concerns about the safety of the people in the Indian custody. And the next is erosion of the democratic values. That means the custodial torture often violates the human rights, even violates the Article 21. And you can see that in 2021, during the time of COVID, a father and a son was severely tortured in the custody, and both of them died. So therefore, if there is no standalone law to take action against the custodial torture, then it contradicts India's commitment to justice and human rights. And the next is global reputation damage. That is, non-ratification places India among the authoritarian regimes, like I mentioned, Burkina Faso, Sudan, Haiti, and all. And we know that we have the badge of the world's largest democracy, and we have to protect it. For that, we need a standalone law to act against the custodial torture. So what can be done to enhance the safety of the people in the custody? First one is the enacting a strong anti-torture law, that criminalizing the torture in the custody explicitly. And the next is ratifying the United Nations Convention Against the Torture, which will strengthen the India's credibility in the global scenario. And the next is judicial and police reforms, that is strict oversight and monitoring to ensure that the people are treated properly in the custody. And the next is independent investigation mechanism, specialized body to investigate and monitor the torture cases in the custody. So in this topic, we discussed the importance of a standalone law against the torture, against the custodial torture, and what are the problems that can be arise if we are not taking an action to ensure the safety of the people in the custody. So based on our discussion, try to answer this mains practice question. The question is, discuss the need for a comprehensive anti-torture law in India. How does the absence of such a law impact India's legal system and global reputation? So we know that the need is of a comprehensive anti-torture law is essential, because it is needed to protect the fundamental rights of the people, ensure the global reputation of India, and also India can make better advocacy for the human rights in the global scenario. And these are the need to achieve all this. We need a comprehensive law against the torture. And the next is, how does the absence of such a law impact India's legal system and global reputation? That means it will damage India's global reputation as a human right advocate, and at the same time it is placing India as one of the dictatorial nations like Sudan and Haiti and all. And the next you can see that absence of such law can violate the fundamental rights. And also finally, in the way forward, you can talk about the need for an independent authority or a body to regularly monitor the custodial safety of the people. And you can also talk about the need for ratification of the United Nations Convention Against the Torture. So based on our hints, try to answer the question and post it in the comment section. We will review and we will reply for your answer. Telecom Tribunal reforms to handle data protection, please. The article is taken from the newspaper The Hindu, which is talking about the recently released Digital Personal Data Protection Rules 2025, and it is released by the Ministry of Electronics and Information Technology in the early January 2025. So we know that the data protection is a matter, it is the biggest concern these days, right? Because we are all living in the digital world, and we know that in the year 2023, the government enacted the DPDP bill, that is Digital Personal Data Protection Act. Okay, and this is to ensure the data security, privacy, and also to enhance the digital governance in India. And under this, we have something called the Data Protection Board. And now, and through those rules of 2025, the government is bringing certain reforms. And this has become a matter of debate and discussion in the society. So let us discuss more about the article from the mains point of view. So why in the news? Like I mentioned, the data protection is crucial these days, and the TDSAT, that is the Telecom Dispute Settlement and Appellate Tribunal, which is established under this TERAI Act, that is the Telecom Regulatory and Authority of India Act 1997, and this body is responsible for the adjudication of disputes in the telecom sector, and this TDSAT is established in the year 2000. And this will have a chairman and other members. The chairman will be mostly the present judge from Supreme Court, or a retired judge in the Supreme Court, or sometimes it can be the Chief Justice from High Court as well. And this institution has to be reformed to handle the appeals from the digital under the Digital Personal Data Protection Act 2023. And we know that so as per the rule of 2023, as per the Act of 2023, we can see that the appeals from the Data Protection Board will be digitally filed before the TDSAT, and therefore we have to reform the institution to handle the appeals in a better way. And also this draft of 2025 has raised a lot of concerns about the appointment of members to this DPB, that is Data Protection Board. And what is the concern is that the union government will have a discretion to appoint the members to the DPB. And also raised concerns about the feasibility of the TDSAT as an appellate body, because in the beginning it was not an appellate body. So key concerns, let us discuss what are the key concerns. First is the executive control, that is the government's discretion in appointing members to the DPB has raised concerns about its independence and governance. And the next is burden on the TDSAT, because the appeals from the DPB will be digitally filed before the TDSAT. Therefore, it has a possibility that it will increase the burden on the TDSAT. And now we can see that between 2020 and 2025, we can see that nearly 3,448 cases are pending in the TDSAT. And if you give more responsibility to the TDSAT, it may slow down the dispute resolution. And the next is limited expertise. So under section 14C of the TERAI Act, you can see that there should be a technical member in the TDSAT, but currently we are lacking that. And the next is weak digital infrastructure, that is inefficient case tracking and digital filing system hinders online appeal process, and this may further slows down the dispute resolution. And coming to the institutional reforms, what are the reforms can be brought to enhance the TDSAT and to make the institution more effective in dispute resolution? First one is the technical expertise, that is under the amendment of section 14C of the TERAI Act, you can see there should be an expert in the TDSAT with good knowledge in digital law as well as in digital governance. And the next is capacity enhancement, that is increasing benches and judicial appointments, and also increasing fund to manage the caseloads. And you can see that in 2018 the bill proposed another tribunal to reduce the burden. And there's another committee that is mentioned in the newspaper, that is B.N. Sri Krishna Committee, Justice B.N. Sri Krishna Committee. They also recommended the same. And the next is digital modernization, that is upgrading case tracking technology, digital filing, and legal case management system for seamless online appeals. And the next is accountability measures has to be taken, for example publishing annual reports from the TDSAT, and also statistics to ensure that this institution is working with efficiency. So in this article we discussed what are the concerns. The first major concern in the rules of 2025 is the discretion of the union government in appointing the members to the DPB, that is Data Protection Board. And the next concern was about the efficiency of the TDSAT, that is Telecom Dispute Settlement and Appellate Tribunal. And what is a concern is that the appeals from the DPB will be filed digitally to the TDSAT, and for that we have to enhance the TDSAT in all aspects. Then only we can handle the then only we can expect a good dispute resolution mechanism. So these are the matters that we have discussed, and for that what can be done, that also we discussed. So what is a way forward? So how can we enhance the mechanism even further? So first is strengthening the TDSAT's expertise and capacity for effective resolution. That means strictly implementing the section 14C of the Telecom Regulatory and Authority of India Act 1997. And the next is enhancing the digital infrastructure to track the cases, as well as to streamline the appealing process. And the next is ensuring independence of the DPP. That means if the members are appointed by the central government, then there is a possibility that the fundamental rights of expression can be even curtailed in the near future. So therefore, to ensure the independence of the board, we have to reduce the government discretion and government influence in appointing the members. And the next is exploring alternative appellate mechanism if TDSAT remains overburdened. Like I mentioned, going for more benches or establishing another tribunal to share the case burden. So these type of mechanisms can be, provisions can be taken. So coming to the mains question. So in this topic, once again, I am recapping. We can see that we discussed what are the concerns associated with this digital personal data protection rules 2025. First concern was the about the discretion of the government in appointing the members to the DPP, and the second concern is about the efficiency of the TDSAT. So and what can be done in the way forward. We discussed what can be done to make the system even more effective. So based on our discussion, try to answer this mains practice question. The question is, examine the role of the Telecom Dispute Settlement and Appellate Tribunal in handling data protection appeals. What institutional reforms are needed to enhance its effectiveness? And it's a 15 marks question, and you have to write around 250 words. Write your answer and post it in the comment section. We will review and we will reply for your answer. With this, we are coming to the conclusion for today's editorial analysis. If you like the video, hit the like button, give your feedbacks as comments, and share this content with your friends. And before leaving this channel, don't forget to subscribe and also hit the bell icon to receive on-time update from Shankar IAS Academy. Thank you for listening to us. Thank you for listening to me. Have a nice day.